Who do we have here? Okay, Cord, when do you want to start?
Let's start now. Yeah, I think
Oh my goodness.
Yep.
Go. Ready, set, go. All right. So this is the third session of our changing claims and all kinds of stuff series. So we're applying notifications and differing site condition. We have some more examples, and I think that was based on some feedback we got. So just to remember where we were at. So differing site conditions, unknown, hidden, or latent physical condition materially different from what was reasonably expected. So that's a subsurface latent physical condition at the site differing materially from those indicated in the contract, or unknown physical condition at the site of an unusual nature which differs materially from those ordinarily encountered and generally recognized as inherent in the work of the character provided in the contract. Okay, and I can't see the chat, Cord. So what is a patent defect? So latent defect, hidden, we don't see it. What is the patent defect? We have chats going.
Not yet.
Get everybody warmed up.
Danilo says something obvious.
Yay! Star student Danilo. That's right. So obvious defects. So again, when we go to the site and it's obvious, then it's not a differing site condition. Okay, so this is what we're going to review today. We have a notice reference guide. It's a little bit of that infographic that I wanted to get to you guys. Then we have a demonstration of documenting these things in ACC. So it's a little bit of starting to use ACC for changes. How are we going to document it? Where is all of that backup going to live in the system? And then we have our differing site condition checklist, little bit refined from last time, and then a good amount of examples. So hopefully we can drive the point home as to what we are talking about. So here is a notification guide that Cord and some of the DOT interns came up with. So maybe it was just Cord. Again, with extracting some of the notification requirements from the spec. So you have the changes, 104.02. So when is the verbal notification required? When is the written notification required? And then once that is sent, the notification of potential claim, the response from the engineer is due within 10 days. If that doesn't happen, the contractor is directed to deem that it has been rejected. So if you want to do anything else, if you want to extend it, make sure the documentation supports that. And then the contractor has between 30 days and 180 days. The spec's a little bit iffy. Between 107 and 104, it allows 30 days, but it also allows 180 days. So these are the notifications. This is when people have to turn things in. This is what we should be reminding them of. And when or if the contractor fails to do this, then that is a waiver of their condition under the contract. At that point, we legally do not have to entertain the change. So that's the important part of this. Okay, I'm going to turn it over to Cord.
Right.
Move this thing.
Give me 1 second to pull up. Alrighty. So when we're talking about changes and notifications, there is ways that we would like to track it within Autodesk Construction Cloud. And best practice currently is number one, to start off with the notifications and tracking that within correspondence. So there are a couple different ways, and I know ACC has detailed guides, but I'm just going to go over briefly different ways to track correspondence within ACC. So the first way is to obviously create the correspondence within ACC itself. So you're able to go to the correspondence module, which is within Autodesk Build, and then click create. And then you're able to, it's just almost like an email, but you're able to send it from Autodesk Construction Cloud, and then you can add an attachment and it'll all be tracked within the correspondence module. And also what's super important here is you can reference the different items within your project. So instead of going to an email and having to go back and forth and take a look at RFIs and download PDFs and attach it here, you're able to automatically reference them here. But we understand that sometimes you won't always be able to create it from here. So there are other options. And if you look right here on your left side of your screen, you're able to see file from email. So two ways. If the email already happened, if the correspondent, let's say a contractor submitted a notice of potential claim already. So what you'll do is you'll click upload emails and you can download that email file and upload it here. And thereafter it'll show up here. Additionally, there is a project email address. So you're able to copy this email address, and if the email has not been sent out yet, you can tell your contractor to send it to this or to CC this email or BCC the email or send it directly to this email. So if once that happens, if this email is if this email address is included, then it will automatically go to this module within your project and be tracked like this. So just a couple of things to note here. Just for an example, we tracked the notice of potential claim, number one, for a differing site condition here. So this is what it'll look like if you send it out from ACC. You'll have the attachment here. You'll have an activity log. And as I'll show you in a little bit, you can reference different parts of the project. And this will all be connected to the issue and starting to track changes, track potential changes within Autodesk Construction Cloud. And that all starts with an issue, an RFI that begins within ACC. So for example, tracking notice of potential claim number one, and then the engineer's response, tracking correspondence, and then also the actual claim after, just like following the guide that Kai just showed. It went through the process of notice of potential claim to engineer's response to the claim to the actual claim. So moving forward, that's correspondence, and that's how that's the best practice to track the notifications within the system. And now tracking all of that in one place, so not only just the correspondence, but tracking the initial risk, the initial potential change should be within ACC issues. So for example, we have an issue here for a differing site condition. And if you want to create an issue, you're able to do so from this module here. You're also able to do it from ACC Sheets. But the point is, we're talking about differing site conditions here and various different changes. So you're able to go in, click the type of issue, and then describe it, assign it to people, give a due date, start date when it happened, and again, attach your files. And later on, I already created one here. So if you take a look at the right side of the screen, you'll see the status that it's in. So if it starts from open and somebody's dealing with it, then you're able to change it to pending and review, close, and you're able to add different statuses if you'd like to customize those statuses of where the issues are at. But the point is that we're all tracking the all of the different modules and all of the different items that happen within the issue or within the change. So for example, all the correspondence that I showed you earlier, all of this is tracked here within this issue. So we have the notice of potential claim that happened first, and then we have the engineer's response, and then we have the claim. So this is all tracked. And the moment that you're adding it to this issue, you're able to see and track when it was done, so that later on, potentially down the line, right, you need to go back and reference this, and you can have a timeline and see when everything happens, to have everything here within this issue already. So I know you can't see the photos right now, but added photos also. You can attach it to the sheet, the specific sheet that the issue comes from, or where it is on your plans, right? So you're able to attach it from there. Additionally, one of the neat things is are also RFIs as well. So it potentially started off as an RFI. So you're able to track all of that within the issue module. And the neat thing is schedules, where you're able to track how it potentially later on, if it affects time, you're able to track that specific schedule activity, and how it affects the entire overall schedule directly within the issue. And then potentially later, if you need to have all of that in one place and convert it to a PDF, then you're able to export it and get a detailed summary of everything that occurred with dates, with the activity log, with a summary of what happened. So again, we're talking about applying notification to changes in DSC. So we want to be able to track that and document it within ACC, be able to document every step. So more to come on best practices and guides for this, but just wanted to show you some of the best practices at first.
Cord, in the chat, Calvin is asking if there's subfolders. I think the way it works is more with the pins. I'm not sure if that's the right wording. So basically organization.
Yeah, so there's various different ways, and one of the neat things you can do is for correspondence is filtering. It's similar to like a submittal or an RFI, and where you can filter it for some of the different fields, like dates, like who is it from, something in the title. You're able to filter it based off of statuses of correspondence as well, open, ongoing, closed. So that
and
is some of
also
the
type, right? What is it? Because it's got the general correspondence, and I believe we can create various types. So if it's a change in claim, if you want to track changes separate from potential notice, from claims, so we can create all those different types. You can do it individually. If you have some recommendations on how you might want to see it, let us know.
That's correct.
Okay, back to our show. So again, we talked about this last time. Cord had put together a checklist for you to go through this merit determination with differing site conditions. So this is the flow. First, we want to confirm compliance with the notifications. So I kind of highlighted red what that primary purpose of that box was. So confirming that the contractor provided their written and oral notifications. I could actually hear it go off. All right, so the first box is the notice. Second box is a site investigation, and I believe Cord is posting a little checklist for you on ACC. The next box is we're going to go and evaluate the contract representation, because again, if did the contract plans and specs borings affirmatively indicate that there were differing conditions? When you review the plans and spec, what was our representation as the owner? You look at your geotech, your boring, your any as-builts from previous jobs within the area, pull the records of prior site investigations or pre-con photos, determine whether the differing site was reasonably foreseeable based on available information. Did the contractor rely on the contract documents to put their bid together? And we want to check for disclaimers. So a disclaimer is basically when we put the information into the contract drawings, did we say this is for information only? Did we say contractors shall use this at their, that we're not making representations of what that information really means? So that can help us or that can hurt us. So it just depends on what the actual disclaimer might be, because it can conflict with an implied duty of fair dealing, meaning
if you know, we're going to talk about the superior knowledge doctrine again, but if you know there's a site, there's an issue there, and again, you have to know, you can't just suspect it, but if you know, then you have a duty on the owner's side to disclose that. And so, we probably need to talk to design a little bit about this, but it may raise the bar for the contractor to prove material difference. Because if there is some representation in the contract and then they ignored it or they didn't price it, then again, that was the risk they took. Then we want to make sure we're evaluating whether there was a material difference. So again, was it obvious? What did the plan say should have been out there? Was it obvious? And was it materially different? It can't just be a little bit different. It has to be almost significantly different. Assess whether the contract could have reasonably discovered. So again, in our condition where it's wet soil in Kauai, now if it's wet soil in the Grand Canyon or some desert, maybe that's not something reasonable, but we have to look at that. And then the next box goes to, gosh, this little box is always, was there, so again, they could have complied with notification. You did your site visit. You evaluated the representation of the contract. Yes or no, it was materially different. All of those criteria could be yes, but you also have to establish that there was a direct impact to the cost or schedule. Obviously, so that the point of it is, was there an actual impact? Was there damage? Was there change? So if there's no added cost or delay, the contractor can't demonstrate that the differing site condition caused anything, then it goes away. Again, did they use the same means and methods as they had anticipated with their method statement? Was there a lack of cost segregation? So if they can't show that the costs were increased, that's the burden on them. If they can't do it, again, it's denied. And then the float or idle time is absorbed. Again, if they were using the float, then the condition didn't cause a direct impact to the schedule. So that's the last part of the evaluation of merit to determine whether there is a differing site condition, whether it merits compatible or equitable compensation. Now, the rest of the change process continues. So again, as we talked about in ACC, we want to start using the correspondence module. There'll be more coming out right now where we have headlight with the primary body of the change order. We're going to work to have some of the backup documentation in ACC so you complete it as the change process continues. So when you have the findings, you have your correspondence, a lot of that is going to be the references to your change. And then we want to coordinate the cost and schedule impacts. Again, under issues, you'll start collecting that information, putting in your ICE. The notifications and watchers and everything will help you keep those things private, but it'll allow you to save it in the system so that all your backups in one place. And then obviously we'll go to finally processing the change where we have all that documentation. Again, what we're moving towards is having the backup in ACC. So as we develop those best practices, we'll post them and let you know when that, the whole thing, ideally headlight has a change order and the links to the backup information is in ACC, and that's how we'll proceed with the change. Okay. I'm going to turn it over to Cord, maybe not.
Yes,
Yeah,
I'm gonna
go
see the
ahead.
screen one more time. One more time.
Yeah.
Okay, so as Kai mentioned, we have a differing site condition merit checklist, and this is already within the ACC library. So you folks on all of your projects will have access to this form at this moment. So it essentially is the same thing that Kai just went through, same steps. However, it is a form built in within ACC. So you're able to connect it to the issue, connect it to all the correspondences. But it has the same sections, and one of the sections is the prompt site investigation checklist. So was the joint site visit conducted with the contractor? Was it patent? You have the ability to say yes, no. And then you have the ability for all of the other sections to explain and to all track it on within this form. And then you're able to connect it to, again, the various correspondence issues, all of the documentation of the basis so that you can keep track of it here. So just wanted to briefly mention that this form is available to you on your projects right now. So if you're dealing with the differing site condition, go ahead and utilize this form to start tracking the important steps to walk through when it comes to determining merit for a differing site condition. So with that, I'll pass it back to Kevin.
Unmuted. All right. Okay, so let's go through some examples. And this is the reason we chopped this into a couple just to slow down the pace and make sure we kind of understood what was going on. So this is the hard rock layer. So a lot of the differing site obviously is going to be subsurface. So during the subgrade excavation between station 20 plus 50 and 23, the contractor encountered unexpected hard rock stratum, roughly 2 to 3 feet below the design subgrade. The plans and geotech report included borings spaced at 300 feet, but did not show any rock in the segment. Instead, the geotech reported soft, silty clay with high moisture content. And the design engineer assumed approximately 15% wet, unsuitable soils across the site based on those findings. This was factored into the earthwork bid quantities. However, the contractor hit hard riprap at that required hoe ramming and ultimately blasting, and a major deviation from both subsurface data and anticipated work methods. So again, the method statement didn't call for using this equipment, and the subsurface data didn't indicate these conditions. So the contractor submitted their written differing site condition notice after 3 calendar days, paused excavation in the site, and provided supporting documents, the log as well as photos. The bid tab analysis showed the contractor's bid for that rock excavation was 10.75 per ton, and other bidders ranged from 25 to 38, indicating the low bidder assumed minimal rock consistent with available data. Okay, so that's the situation. So we're going to go through our analysis. So we're going to confirm compliance with notification. Again, I believe, where's my little notification reference guide? So verbal, we didn't talk about verbal, but we're going to assume they did verbal. The written is differing site condition actually requires 5 days. Is that correct? 5 days. So they did it within they did it within 3 days. So they met notification. The work was suspended. The notice of potential claim included the information required. Follow-up documentation, including photos and logs, all of that was submitted. So result, it was compliant with notification. So the next step is to conduct your site visit. So the engineer and geotech staff inspected. The depth of the rock was 2 to 3 feet below subgrade, and they observed dry weather, unrestricted, So basically, when you're doing that, you just want to do a diary with observations in your log. So the result was that they did field verify and aligned with the contractor's claims. So again, we've got notification, the site visit confirmed it. So now let's see what the contract said. So the contract was comprised of the plan sheets with cross-section and grading contours, the geotech report, bid tabs, the pre-construction photos, again, couldn't see the condition, GIS utility geology overlays, and there were no anomalies that was available. So documentation indicated that there shouldn't have been hard rock in this location. So now, was it materially different? We have to compare the actual to the indicated. So the contractor encountered materially different conditions, hard rock versus the moist silt soil. Plans and specs indicated the soil excavation and minor unsuitable subgrade, not blasting. So there was a wet soil condition, but not blasting, not ordinarily encountered in this type of work. Rural road widening, it was a reasonable pre-bid site visit would not have revealed it because you wouldn't have seen it as 2 to 3 feet. So yes, it meets the criteria of material difference. Now, was there direct measurable impact? So the cost, the original assumption of soft soil removal had standard excavation. The actual condition required hoe ramming and blasting, which increased the cost. So over the quantity, that's 27 or 26,700 was added. And then again, the equipment mobilized was different than what was anticipated in the method statement, which comes with the baseline. So that's why it's important to get that information. What was the schedule impact? Blasting required coordination, so that delayed the excavation by 60 calendar days. The area remained unworkable until blasting completed. Downstream activities, placing base course and trenching, that delay was delayed 14 days. So the documentation with the daily diaries was kept. We recorded the labor and equipment, photo logs, everything. That was the documentation added to ACC. And then the contractor submitted a CPM schedule showing the delay to the critical path. So from a cost standpoint and a schedule standpoint, we've determined that there was an impact. So one of the things I was thinking, well, okay, so we had the impact. Everybody knows there's a delay. When do we actually start counting the delay? Because the specs doesn't really say. So what's the reasonable determination? So when do we start counting that delay? And I think these are the things, this is kind of when you know, in your meetings, when you're talking about delays, make sure you work with the contractor and understand, because it's really a reasonable time. And what is a reasonable time? So we had the durations on the previous slide. So the owner is given time to reasonably assess the situation. So it's not defined, but it's interpreted as fair. So what is fair? And it really depends on the situation. But I guess the point is, it doesn't start at the time of encounter, and the contractor has a duty to mitigate the delay. So they have to go and work, you know, what can they resequence? What else can they do? So there are inherent deficient or inefficiencies that could help with this kind of change, but you do have to respond. And what is that reasonable time frame to give them direction on how to proceed with the differing site condition? So if you do your analysis and you determine that it's a change, then you can respond and say it's a change, and that way they can immediately either mobilize different equipment or work with you to minimize whatever that duration is. But the counting of the delay does not necessarily start with the day of notification. That's the primary driver here. So after reasonable determination, did we act as if no decision is made, the contractor is still unable to proceed? That's when the delay is going to start accruing. So it's really going to be you working with the contractor. The period could be considered compensable if the contractor acted reasonably, they provided timely notification and documentation, and they were ready to proceed. And for whatever reason, we were unable to give them an answer. So again, somewhere in, depending on the magnitude and what the change is, I don't want to state a time, but I'm going to. I feel like a couple weeks. If it's more complicated, maybe 3 weeks. But at some point within 30 days, a delay should be tracked, and it most likely will start accruing against the owner until we can provide a response. Okay, so again, we're going to continue with the change process. We've determined there's merit under differing site condition. We've gotten our information, and hopefully we've provided direction. You know, we can start tracking the change under force account while we're waiting for proposals and do a conversion. Again, I'm not sure if Federal Highways is on, but at one point, the direction was if you proceed with the change, we're not we're going to start tracking it as force account. We're not going to track it as a prepaid estimate after the work is done. So make sure you're tracking whether, are you getting a proposal? If you're not getting a proposal, it's going to be based on time and materials and force account method. You could probably convert that to a lump sum or some other change order, but as soon as it starts, make sure that that time and materials is being tracked in the field. So we're going to document and communicate our findings. We're going to coordinate getting proposals and cost impact analysis and schedules. CCO justified for additional cost, and then 7 calendar days. So again, the durations that I determined that I communicated at the beginning were 60 days and 14 days, but when we really analyzed how it affected the critical path, it was only a 7-day delay. And we'll talk about time impact analysis along with the cost. I know Joel's been starting that, so we'll do a continuation of that. Then we're going to execute the change and continue on our merry way with probably some other issue. Okay. Any questions on that example? That's kind of the easy one, but we did want to introduce what is that reasonable time frame, because the delay does not necessarily start as soon as notification is given. All right, so here's our other example. Within the first week of construction, while excavating for a box culvert footing, the contractor encountered highly saturated, unstable soil, which was much worse than anticipated. And the plan showed compacted fill, native clay, but actually the material was mucky, light, highly compressible, almost swamp-like. Contractor chose to proceed with dewatering and importing gravel for stability. Notice of differing site condition was not submitted until day 21, along with a cost request for excavation overrun, dewatering equipment, and standby. Okay, now we're getting complicated. So we go into our first test, right? The first thing was notification given. So if the contractor failed to provide notification, it was submitted 21 days later after work had progressed. There was no RFI, there was no verbal, work was not suspended or delayed in the area. The contractor failed to provide the DOT the opportunity, which what is that word when they are taking away our opportunity to mitigate in the chat? What's the word? So they did that. Somebody comes up with a word, they'll get a gold
Proceed
star.
with their own volition.
What? No, it's one word.
Oh.
One word. Anyway, so contractor failed to provide
There we go.
notification.
Prejudice. Everyone got it.
Prejudice.
People got it.
Man, look at that. Good job, Calvin. Danilo and Francis. So they prejudiced our ability to mitigate. So I think a part of my thing with notification is that if they take away our right to do something different, why should we have to pay for it? Anyway, so based off boring logs, soil condition may have different material from the plans with the highly saturated muck. So it's almost like we probably acknowledge that there is a difference, but you failed to do all these other things and you precluded the owner from mitigating or coming up with a solution. Then that's when you start to waive your rights under the contract. So upon investigation, DOT determined the claim to be time barred due to failure to submit timely written notification in accordance with the contract. So they failed step 1. Okay, so that's that example. Next example, we're going to go straight to the material difference. So during an excavation, the contractor encountered a layer of rock approximately 3 feet below existing grade. Contract documents included geotech boardings at 500-foot intervals. Nothing showed up. Contractors submitted differing site condition notice and stopped excavation in the area. They claimed the rock required hoe ramming and pre-drilling for blasting, which would increase cost and time. So they provided their notification. In this example, we're also going to assume they did their site visit and it was completed. The contract representation did not show the layer of basalt that existed. So we've gone through steps 1, 2, and 3. Now we need to determine whether there was a material difference and a measurable impact. Okay, so one of the ways we can do that is looking at their bid tab. So when the low bidder came in, what did their price look like compared to the rest of the field? So in this case, the low bidder was lowest in that bid item. The low bidder's price significantly below the others, the engineering estimate and the other competitors. This suggests that the low bidder reasonably relied on the contract documents, which did not show rock, and bid accordingly. So the low bid indicates the contractor was not pricing for hard rock conditions, supporting the argument that the condition was materially different than what was shown or implied in the bid documents. So if the low bidder priced very low, it usually suggests they believe the work was easier or less costly. No work in this case, or no rock in this case. If most of the other bidders and the engineering estimate are higher, they may indicate that the other bidders assumed rock might be there despite the borings, or they hedged their risks, not sure what was underground. The low bidder priced it at 15 cubic yards, assuming soft soil based on the contract documents. The other bidders, 3 times as much, which could suggest they were more cautious, not that they knew for certain there was rock. Oops. Okay. The engineer's estimate was at 46. That supports the agency itself may have anticipated the possibility of rock. So this is it's kind of interesting because now we have a scenario where the low bidder assumed nothing, and it looks like the rest of the pack, including the engineering estimate, assumed that there might have been rock. So in my mind, well, was that superior knowledge? Did they know, and should we have disclosed that? So it might have been superior knowledge if the owner had actual knowledge of the rock and failed to disclose it, despite the condition being material different and not reasonably discovered by the contractor. So you might have that situation. Oh, okay. Otherwise, the engineer estimate, even if it included rock, that's not generally shared with the contractor. So even if we had it, the contractor did not have that information. So again, they could not have used it in their bid. It wasn't known knowledge. The contractor can't be expected to guess what the owner internally budgeted for. Uh-oh. Yeah. Okay. So even though our bid is higher, we came to conclusions, but that wasn't shared. So it may not be superior knowledge. But let's look at what all the things need to entail in order to be superior knowledge. So if the material information was known by the owner, so again, we talked about superior knowledge, but I wanted to apply it to some of these examples. So we talked about, does the owner know something? So if they were just estimating and basing on engineering judgment, that's not superior knowledge. The owner had to have actually information that contradicted the bid documents, internal boring logs or some other information. They need to not share that with the contractor, so the information was not made available in the bid docs. The contractor could not reasonably have discovered that. So again, if it is public information out in the ether that's available, is it reasonable that the contractor would have known it, would have seen it? Was there a large court case involving something in that area that everybody kind of knows about, a reasonable person? And did the owner know the contractor was unaware of it? So basically, are we trying to deceive the contractor? So that's superior knowledge. So in this scenario, it doesn't really fall into that. So if differing site, so I'm just bringing this up, and I don't know if we really do this, but if the differing site condition exists and there's evidence of superior knowledge, the owner should have known the condition and failed to disclose it. So again, there's some responsibility on our side to understand what's going on our project. If we feel like it's something that needs to be known by the contractor, we're either putting it out there. Maybe you add a disclaimer statement to that so they see it, but you may not know the extent of it. You may not understand whether it's going to be a material difference or not, but you put that in the bid documents. The contractor, if we don't do that, the contractor may be entitled to additional compensation beyond just their direct costs. because we knew something, and that's why when you look at the engineering estimate versus the contractors, like what was the knowledge, because that does open up it. In one case, opens up the ability for you to potentially negotiate other costs with this because of that discrepancy. So if superior knowledge caused the contractor to mobilize different equipment, I know sometimes contractors will ask for additional mobilization, sometimes they won't. In this scenario, they would be very much entitled to it. Obviously, standby and labor efficiencies, we don't usually entertain labor efficiencies, but in a superior knowledge scenario, that might be required. And then any administrative remobilization costs, temporary protections, resequencing impacts, all of those might be additional compensation that is warranted for adjustment if we had that knowledge. So I thought I would throw in that little example. So why superior knowledge elevates the claim? Basically, unlike a neutral or normal differing site, proving superior knowledge shifts more of the risk and blame to the owner. So opening the door, not just the cost, but damages, inefficiency, deception, things like that. I think in the first one, or maybe it was through research, there was a Hawaii case where they got not only differing site condition, but superior knowledge. So I wanted to kind of throw that example in there. Okay, I see questions. Yes, so design will evaluate all their contract bids. They're looking for unbalanced bids, front loading, things like that. Ability, so does the contractor have the ability to reallocate overhead into certain contracts like excavation? Um, I believe that is correct. The contractor can put their costs anywhere within the contract. That's part of their bid strategy. So um, if it's highly unbalanced, if it's highly front loaded, those are grounds for rejecting the bid. I'm not quite sure if we do that, but I know there has been a case of unbalanced bid where some districts actually canceled the procurement because of that. I don't know if we've awarded, maybe if somebody's here and they awarded to a different person because of the unbalanced condition. I think on the safe side, we've just canceled the procurement. Oh, sorry, this is the example. Okay, so here's another example. Again, we have a rock condition subgrade. The geotech report includes borings. It shows a mixed layer, mostly silt with possible rock gravel pockets. And the plans indicate anticipated excavation includes a mix of soft and medium materials. And then when we look at the bid price of the contractor and the other bidders, it's all kind of in the same range. Bid spread indicated low bid, possibly based on assumption of no rock because it's a little bit lower. So in this example, we're assuming notification was complete, the site visit was complete. Again, now we have to determine what was the contract representation, was it materially different, and was there an impact? So during excavation, the contractor encounters several areas where we have gravel and compacted soil that required heavier equipment than initially planned, and the contractor files a claim under or a potential claim or notification that there was unexpected hard material. So the contract representation, again, after the other two, this is the third step. Geotech report did include references to gravel pockets. Plans did not guarantee only soft soil, so there was no false or misleading representation by the owner. The contractor used a ripper and loader, no ramming or blasting. Work was completed on schedule, so the final quantity of the hard material was less than 10%. There was no material difference, so it was within a reasonable range as represented by the contract. And then was there an impact or cost? No time extension was requested and no supporting cost data showed a measurable impact. So basically, there's no measurable impact. They may or may not have used a couple of different pieces of equipment, but they stayed on schedule. This is a great example of a contractor in a conservative approach should always provide notification. We should always go down that road. And at the end, it may not be materially different. It may not impact the schedule, but at least we've gone through the process. We've provided notification and we make sure we follow and look at that merit determination for differing site. Sometimes it's not gonna happen. So the claim is denied or the potential change is denied, although there's some variations in the subsurface conditions, the difference were within reasonable expectation based on the contract documents and did not rise to the level of materially differing site condition. So again, we can have those scenarios, but if it doesn't lead to a difference, it definitely lead to an impact. Obviously, there's no change. Okay. I'm actually might be finishing early. I thought I had another example. Okay, so that's kind of what we prepared today. Move that. Do you guys have any questions? It's a little bit of a repeat of what we did, but I wanted to provide a couple more examples and really get that checklist out to you so you had a guide on going through that process. Hopefully it's crystal clear. We're going to be continuing with the series. So again, we've talked about notifications, we talked about differing site conditions, and embedded in those classes are a ton of little doctrines, prejudice, superior knowledge, duty to inquire. I'm not sure if we did the other one. What economic waste? Did we do that one? We had a couple in there. Okay, so I'm cutting you loose early. Do you have questions? What's the next one in our series? I don't know if I have that up. Okay, I see no questions. All right. What if the work does have material difference? Boring logs, but they encountered a lot of rock. The contractor didn't stop work or let us know they were pricing it differently. They only sent force account sheets 1 month. Would they be entitled? So great question. Let's go through the process. So the beginning of our process is the very first step is notification. So in that scenario, so we're here at the, let's see if I can play it. No, that's not what I wanted. So our very first step is the notification requirement. It sounds like that scenario did not meet notification. That's the whole reason of prejudice, that there was prejudice against the owner, prejudice against the owner. They took away our right to do anything, to change anything, to direct anything different. So you can deny the change just for lack of notice. So again, you're going to work with your construction engineers within your district, because this is not always done right now. And we'll have to talk more and more about how the construction engineers are going to treat that. But that would be a reason. Step one reason to deny the claim is they failed to provide proper notice. So one of the claims or changes I'm working on right now that is years old, telling the contractor, you didn't tell us, you didn't give us time proposal. They're asking for time impact, basically because they got LDs and there were unilateral changes giving to them, and they're claiming time and overhead, but they never submitted it. To this day, they have not submitted an appropriate time impact analysis with cost still. So this happened 3 years ago. So why should I pay you if you haven't done that appropriate documentation? So right now, the only reason to do that is because all of DOT does it. So as we migrate to, or we push forward, maybe not, again, it's up to the construction engineers, we can deny on just notice. And the reason I prefer this is because of the situation we're dealing, probably in a lot of cases, but for me right now, 3 years ago, something happened, they want to get paid, they never turned in the proper notification, and the project's done. So how do I mitigate that cost? How do we have a recovery schedule? We could have had a recovery schedule and maybe we pay them overtime to finish earlier to mitigate the overhead costs. But you didn't tell me, you didn't provide any costs, and now you want me to pay. So it's just, it goes back to fair dealings. Is it better to grant time extension on actualized time or time requested? That's, a lot of it depends on what you can do, but I personally would rather do it, even if we have to do it on a projected analysis. I think right now we all wait until the delay is over and then we analyze it. I would love to get to more proactively doing it, but that doesn't always happen. So, as long as they provided notification and you're working with them on the package to be submitted to support that change, then I think it's fine to continue entertaining it. It's when they say they're going to get it and they don't, and then you're dumbfounded. Like I said, if we're moving along and we believe that somebody's going to get assessed LDs, and then right before the project ends, they're saying, wait a minute, we didn't get overhead for this. It's like years later. It's very difficult. But because most of us are doing it right now, it's also very hard to deny. So on my projects, I'm looking for reasons. Is there some reason we're entertaining it in this scenario only? So that at least on paper, we're saying why we did it on this project, and that doesn't mean we're going to do it on every project, but there are special circumstances. So, okay, Andrew's question, if the lowest bidder has a low bid in particular item, does the state construction before awarding ask the contractor that they are low on particular items? If their bid is okay, do they want to withdraw their bid? Andrew, I think that I believe that process happens in design or in the district design. So if there are differences, I've heard of procurement offices just not giving the contractor an opportunity to withdraw their bid. Anyway, I'm not sure. I know it doesn't happen on the construction side. It would happen during that bid phase. Yeah, and if you have a follow-on, let me know. So another one, what if the work does have material difference, but the contractor didn't stop work and let us know they were pricing it differently? Wait a minute, that was the same one, right? Or did that move? Sorry, I already saw that one. This one. What if the earthwork quantities different greatly, showing a balanced job and possibly import, but the project ended up having $10,000 excess material? Special conditions says contractor responsible for disposing excavated material. Also, lots of notes in the issue for bid and contract set that says earthwork quantities are for purpose of grading permit. Quantities didn't include trenches. Would they be entitled to additional costs? So number one, let's go through our thing. One is, did they provide notification? You're not saying that, so I'm assuming they provided notification. If they didn't, I would, again, depends on your construction engineers, but according to legal precedent and doctrine, they have waived their rights to the change because they didn't provide proper notification. Then we go check site visit. What is the site? What is the change actually? So we have to see it. Again, if you go back to the definitions of the site, subsurface or latent physical condition of the site that differs materially. So is there a physical condition or unknown physical condition at the site of unusual nature, which differs materially from the work? Okay, so we're going to do a site investigation. You have to make that determination. If it looks like, well, this is kind of the work you signed up for, then let's go to the contract. And if the contract had some notification, special conditions say contractor responsible for doing those things, and there's a ton of notes. So from your description, it looks like there were conditions in the report that provided the representation that that would occur. So was it reasonably foreseeable? And did the contractor rely on that to do their bid? So that it sounds like the contract documents were reasonably represented the situation. So again, that's probably the hard part right there. And then was it materially different? Now you're saying the project ended up having 10,000 cubic yard excess material. This is removal, I'm assuming. Again, was it materially different? Kind of sounds like it might have been, but I think it goes back to how strong the contract represented it. 10,000 cubic yards. PMs review the bids, then make a recommendation to Con. Excavation can be overrun, additional fill. Okay, so in this example, it really depends on the evaluation of what was represented in the contract plans. If it looks like they reasonably should have known that, then it probably should be denied under that scenario. And then Calvin's making a comment that construction does review the bids and makes recommendation if they see something to, is it to Con? Is it Con or is it to whoever the design project manager is? Let me know. And then Calvin's making a comment that excavation can be an overrun. Again, depending if it's unit cost, we have that built-in over and underrun scenario without repricing. Con. Okay, so it looks like Con may get comments from construction. I think that's what you're saying, right? Okay, so hopefully that's helpful. I know there's a ton of nuances in all these things, what was in there, what wasn't in there, what was reasonable. I really like the fact, looking at the other bids to see overall what the rest of the pack might have bid versus the bidder we have. And again, it's DOT's has not usually denied these things on notifications. So that's a shift that we'll have to work with the construction engineers to see if they're comfortable with that type of thing. Okay, so again, we're at time. If you guys have questions, we'll hang on for another little minute, but I want to thank you and happy change ordering.